It isn't often we get to see you on the This is the part of the workshop representing immigrants. Representing immigrant parents and parents of immigrants can make already difficult travel or decisions even more complicated. Issues ranging from language access to detention hurdles to consular notification requirements under international treaties. In some instances, the court matters of immigration status options for children and parents, and in others, immigration status concerns may obscure the juvenile court process. This section those and other issues of the intersection with us. University College. Writing seeks to develop frameworks and critical perspectives for analyzing the intersection of family and immigration with a particular focus on children. Previously, he served as acting assistant professor in the Lawyers Program at NYU Law School and as professor and associate dean for clinical studies at UNLV, where he founded the law school's immigration program. He graduated from the University of Kansas with degrees in mathematics and education, and then taught in Nepal as a Peace Corps volunteer. He completed a master's degree at Columbia University and served several years as a teacher and assistant principal in the New York City Public Schools. He earned his JD in public policy. Veronica Thronson is an assistant clinical professor of law and director of the Immigration Law Clinic. Previously, she was the directing attorney for the Domestic Violence Project at the Legal Aid Center of Southern Nevada, where she practiced in the areas of family and immigration law from 2002 to 2010. Thronson was also a director of training and legal services at the New York Immigration Coalition, a nonprofit umbrella advocacy organization for over 200 groups in New York that work with immigrants, refugees, and asylees. She served on the advisory board to the National Center on Immigration Integration Policy at the Migration Policy Institute in Washington, D.C., and was vice chair of the Nevada Network Against Domestic Violence. She also taught community property as an adjunct professor at the William Boyd School of Law at UNLV, and she joined the faculty of the National Judicial College in 2012. Please welcome David and Veronica Thronson.
Just like law students, and you start at the back and go forward and leave a gap. And for a group this size, we probably couldn't have a less intimate setting than we have here for legs, but we'll try to a lot of ground to cover, much more than we probably can. The slideshow we have up here is not new material, but we'll make sure we make it available to you if you want to get after as we listened to the plenary session this morning, had this woman been an immigrant, off the road, this whole scenario would play out vastly different. Not necessarily. And then we just have family dynamics, our influence. Immigration status is something that changes power dynamics, changes relationships, changes roles in families. And so as we're working with immigrant families, we're working with whether they're, all immigrants or whether some people in the family are immigrants, knowing something about the immigration framework within which they're living helps us understand a little bit about how this family works and how they talk and how they communicate and what happens to them. So we want to hit those issues. Now, we're strong believers that immigration laws are things that need to come out. There's a tendency a lot of times to say, well, someone's here undocumented, that's something we want to hide, that's something we need to push under the table. We don't want to talk about this. We're afraid to make a decision. We're afraid to think about what's going to happen if we talk about these issues. That's an invitation to sweeping things under the rug, letting things come to that decision. We hope by the end of this we'll convince you that these are important issues to put out on the table, to talk about, to challenge our stereotypes and biases so that it doesn't become a negative that we're talking about these things, but that it's positive as we go forward. So to do this, we don't want to turn anyone here into an immigration lawyer. We know you're not. We know that's not going to be your responsibility, your role in the system, whether you're on the bench or representing parents. But we do think you need to understand a little bit about the framework of our immigration system to be able to work with immigrant families. There's so much misinformation out there. Very few people actually understand how our immigration laws work. And the rhetoric here in public, in debate, is really far off the mark in terms of thinking about what rights and what responsibilities are actually there, what options are available for immigrants. So we're going to give you a brief excursion, on what our immigration system looks like, and for that, I'm going to turn it over to Veronica.
Thank you. So you may be familiar with the agency formerly known as INS. Okay. Since September 11th, that agency no longer exists, and now we have three agencies that are under the umbrella of the Department of Homeland Security. And those agencies are Citizenship and Immigration Services. That's basically what INS used to be. Immigration and Customs Enforcement, ICE. They are the people who deport immigrants who are here unlawfully. And then Customs and Border Protection. Citizenship and Immigration Services, CIS, usually is in charge of processing a lot of applications that would eventually allow someone to become legal in the United States. And that goes from applying for permanent residence to applying to naturalization. People who apply for a work permit, all of those applications are housed under this agency. ICE is responsible for the interior enforcement efforts. They start removal proceedings since 2001, since September 11th happened. We no longer deport people, we remove them, but it's exactly the same. So now we say that people are in removal proceedings instead of deportation proceedings. But for someone who's being deported or removed, that's exactly the same thing. It doesn't change anything. We have Customs and Border Protection, and they are actually very active lately, and they are able to come not only at the border, but they can go inside up to 100 miles from the border and stop people and deport them, start a process if they are found to be breaking the law. And then the Executive Office of Immigration Review, EOIR, that's the courts, that's the immigration judges. Then we have, for terms of what you need to know, we have a big divide between people. So we have U.S. citizens, people who were either born here or people who went through the system and later became naturalized citizens, and aliens. That's it. That's all we have, okay? Aliens, and we'll get to that. Aliens are basically non-citizens. So if you are not a U.S. citizen, even if you have an asylum petition pending, even if you are a refugee, or if you are someone who has lawful status, you are still a non-citizen. You are an alien, okay? Of course, and I'm going to use one of David's quotes here. David usually says, but of course, when the Prime Minister from, I don't know, Britain comes to speak to a joint, to Congress, they never say alien speaks to Congress, right? Like they always say. So we usually use the alien to say that something is bad, okay? So we really like to use non-citizen or someone who's not authorized to be here. But aliens can mean many things. So someone who's here as a tourist, someone who's here as a diplomat, someone who's a performer, someone who came here to study in a university, that's an alien. Then we have people who have no status, people who are here, maybe many of them came with visas and then they overstayed or violated the provisions of the visa, and then we have people who enter without inspection. And those people are people who usually cross the borders, right? We call them IWIs, enter without inspection, although it could also work as enter with inspection. But so we have IWIs, and of course some people say wetbacks. But so we have about 55% of people who enter without inspection, and then 45% of people who enter legally, but they overstayed their visas. Let's say they came as tourists and then they were given 3 months to visit and then to go back, and then decided not to go back. So the visa expires, and then that means that they are as undocumented as someone who crossed the border. However, for people who have no status, there are provisions in the law that could eventually help them get status, and we'll get to that a little bit. But just for the fact that you are here undocumented, that you are unauthorized to be here, you could be deported at any time, depending on whether ICE catches you or not, or something that you have done. But if the person would appear before an immigration judge, that person could say, Your Honor, I agree that I have no status here, but I have the possibility of applying for status, and then that person could actually eventually get status in the United States to be here legally. So one of the, well, of course, the best thing to be is to be born here, so you don't have a problem with being an alien. But another...
Just for the record, am I still a citizen if I'm born here and my parents are undocumented?
Yes, you are.
Is there any question about that?
No question about that.
None at all.
Okay, so many people, and I'm just going to deviate a little bit here, many people think that because that person had a child here, that then that person can bring the whole family, or that person will automatically get papers. That is not true. If I'm here undocumented and I happen to have a child here, the child would be a U.S. citizen just for the fact of being born here. But if the child wants to get me papers, the child has to be 21 years of age to be able to start the process for me. And because of my status of being here as an unauthorized immigrant, I would have to go back and stay in my country for 10 years to wait for those papers to process. So that's the pension long-term plan for me to get papers just for having had a baby here. Okay, so people who are here with a legal permanent resident, those are people who have green cards, and those are the people who are allowed to work and live in the United States. They could still be deported, regardless of how long they have had the green card, if they commit a crime, if they are involved in child abuse cases, domestic violence cases, any drug-related offense. The fact that they have a green card doesn't really mean that they won't be put in process to be deported if they do something illegally. Many times they go back to their country and abandon their status. They are not allowed to do that. They are only allowed to remain outside for no more than 5 months, and then they need to come back in order to continue to show that they are here with the intention of residing permanently here. They have to renew the green card. The green card usually lasts for 10 years. So the status doesn't end. It's the green card that needs to be renewed. And then during the process of renewing the green card, they have to go through a system called biometrics, where the government will be taking their prints and their picture, and the government will be checking to make sure that that person didn't commit any crimes during that time, because that will trigger the government coming after them and asking them to appear before an immigration judge just for the fact that they committed a crime and they thought they were just renewing their green cards because of the prints. They will be put in process. If they obtained their green card when they were kids, at age 14 they have to renew it, because usually people change. These are samples of some green cards. They are starting to be green again. They were pink before. So here you have some samples of what a green card looks like. Social Security. That doesn't mean that you have status. That the fact that you may have a Social Security card doesn't mean that you have status. When the Social Security Administration issues a Social Security card to someone who has some sort of temporary status, or just a work permit that will last for about a year, they will have a notation in that green card, and the notation says valid for work only with DHS, Department of Homeland Security, authorization. So they have to show that they have, to apply for the Social Security card, they have to show that they have legal status to be here, but then that Social Security card will have a notation. Okay, so it's not just a regular Social Security card that we usually get. So how do you get status? Three main avenues. As David said before, family sponsor is one of the biggest ones. 74%, 72% of people come through a family connection. Then we have employment base, and we have the visa lottery. There are other ways to get status. For example, people who are resettled and processed outside the United States and enter as refugees, or people who are in the United States and then apply for asylum. Other people who get temporary protected status because there is something happening in their country that won't allow them to go back. For example, the Haitian earthquake. A lot of people were granted TPS because they couldn't go back to their country, and now we are having this new program that the Obama administration has created, the Deferred Action for Childhood Arrival kids. So that's also a status that is going to allow for people to remain and work in the United States for a limited period of time. Employment-based, usually people who have lab skills, not usual, nanny, and it used to be, but not anymore. So they have to have skills, or people who are able and willing to invest a lot of money to create employment in the United States. The visa lottery, there is only limited for a few countries that haven't sent that many people to live in the United States. So I have only met 2 people who have, in all these years of practice, I have only met 2 people who have gotten the visa lottery. Last year they messed up and sent letters to people telling them you got in, and then they had to retract and say, oops, no you weren't. And so now there's a lawsuit pending in California for all these people who thought they had gotten the lottery and now they don't. Family sponsor immigration. So who is able to petition for their relatives? So we have U.S. citizens are the ones who are able to petition for their spouses, their children who are under 21, who are single. So in terms of immigration law, you are still a child up to 21. And then you are able to sponsor your parents. That's it. You cannot sponsor your grandma, you cannot sponsor your aunt. You of course are able to sponsor your siblings, but we're going to talk about how that works in a little bit. So the way, okay, family sponsor immigration. So we have different categories depending on what your status is. So if you are a U.S. citizen, you are able to petition for those groups I told you before. And then there are always visas that are ready to be given to your immigrant relative, except of course with the backlogs, it usually takes about 18 to 24 months to actually complete the process and get the papers. But there's no wait list. Then we start with people who have other status, for example, someone who only has a green card, someone who's a lawful permanent resident. That person is able to apply for his spouse and children, and then unmarried sons and daughters. Then we have another category where the U.S. citizen is able to petition for their sons and daughters who are married and for their siblings. That's it. The backlog, it has actually moved a little bit, but we were looking at the visa bulletin, which is a document issued by the State Department that shows how the visas are moving and what they have ready for people who have applied. The 2A preference, they are checking right now people who applied back in March of 2010. And this hasn't moved for the last 2 years. Then we have people who are only legal permanent residents sponsoring for their spouse and children. They are checking people who applied in June of 2004, and then August 1992 for Mexico, because Mexico has its own separate category, because there are too many people. Mexico, China, the Philippines, the Dominican Republic, they have their own category because there are too many people. So the wait list for people from those countries is even longer. People who apply fourth preference is if you apply for your siblings. So they are checking people who applied in 2001, February 2001. If you are from the Philippines, they are checking the applications of someone who applied for his siblings back in 1989. Okay, so the fact that there is a visa that is ready for someone to come to the United States doesn't mean that the person is going to make it in. Okay, because then the government checks for any reason to make sure that the person is not going to bring anything that we don't want. So someone who's likely to become a public charge, someone who's too poor, who's not going to be able to support himself in the United States, someone who has health problems that are going to overload the healthcare system here, someone who has ideas that the government doesn't like, national security grounds, anybody who's suspected of being a terrorist, someone who has criminal grounds, and someone who has had prior violations of immigration law.
I have a quick question.
Yes.
On health-related grounds, could you
Yes.
give an example of what kind of health?
Yes, we used to have a bar for people who tested HIV positive. Now, as long as they can show that they have insurance that would cover the expenses, those people are allowed in with a waiver. So the government is able to provide a waiver. People who have communicable diseases, tuberculosis is a big one. They have to check, and it doesn't mean they won't come in, they just want to make sure that the person has gone through the treatment and is not going to pose a risk of infection to other people.
This is the legacy of the images we have of, thumping chests at Ellis Island to see who's got tuberculosis, right? A TB test is still part of the process. And, much of this, because we can treat disease, it is less relevant as the disease itself, but it's going to trigger the public charge ground, right? Forget, give us you're tired and poor. We don't want you tired and poor. We want you healthy and, well off and ready to invest. Those go hand in hand. So it may be that you're okay on monetary grounds until it's discovered you have some disease which is going to require health insurance and treatment which you don't have, which, though treatable, and you can overcome the health grounds, will cause a problem on the public charge ground because you're not going to be able to show that you can treat that disease and work through that. So these work hand in hand and are a problem for a poverty-based practice.
If you're applying to sponsor a relative or something, while that application is pending for however many years, I don't know where you're from, does that person have any temporary status in the United States, or are they waiting sponsorship application fee?
Well, if the person is waiting outside the country, there's nothing, right? Because they are just waiting. They have a petition pending, maybe a family petition has been approved, but there's no visa yet. So then that person has to wait to do the consular processing because they have to do it outside the United States, including doing the medical. And the medical will be done by someone who has been certified by immigration. It's not any regular doctor. It has to be someone who is approved by immigration to be able to do that test. Now, if someone who is here, let's say David and I are married to each other and he has petitioned for me and I'm here, it could be that...
Statistically, that's more often the case, even though the law presumes otherwise.
Yes, so, they usually say, why don't they stay, why don't they go to the line or something, but there's no line to join. So let's say David and I are married, he has petitioned for me, then I wait. Because he is a U.S. citizen, I could possibly apply for a work permit, except that if I enter without inspection, I could still be deported if ICE catches me. And I have no right to get any status while I'm pending my application, despite the fact that I may be having 5 U.S. citizen children and married to a U.S. citizen. So the fact that you have an application pending doesn't really mean much. Although it could be used as an argument to tell the judge, I have a petition pending, but right now they are checking 2004 and we applied in 2010. So there is not even a visa for me yet.
But Veronica touched on something that's a really sort of insidious aspect of immigration law that doesn't
Likes to take
appear.
over the presentation.
Yeah, we're married, so I think she'll do the same to me. So, whether or not someone entered with inspection into the United States determines whether or not they're permitted to process their application here in the United States or whether they need to return to their home country and process through our embassies or consulates abroad. Now, that sounds like a distinction that we could look at and say it doesn't make a big difference if you process one place or you process another place. The problem is that we have attached bars that sometimes go as long as 10 years if you're undocumented in the U.S. and you leave the country. So that may be a 10-year visit to go process abroad. And if we look at who that impacts, when we said about half and half, 45, 55 people who overstayed visas, who came lawfully and overstayed, well, they tend to be from countries where we give visas. Europe, Japan, wealthy countries, wealthier people. Who doesn't get a visa, who can't get a visa and enter the United States lawfully, people from south of our border. So people from Mexico and Central America tend to be disproportionately among the people who entered without inspection. They may be in exactly the same family situation with a U.S. citizen spouse and children, but because of that act of crossing the border, they're going to not be permitted to process in a way that the person from Europe who came and stayed 20 years after their student visa expired or their tourist visa expired is permitted to walk through the system and do just fine, and G will give them an employment authorization along the way as they go. So though, nothing in the law says if you're from Mexico or Central America, we're going to treat you differently. Because of the manner of visa availability and entrance, that's a fact that plays out. It's a long drive home.
And he already got a ticket last night, so. Okay, so David touched a little bit on the bars of inadmissibility, and these ones are relatively new, and so that's why people are really not able to leave, because they know that because of the fact of how they enter the country, they have to leave to process their papers outside in their country. They won't be able to come back in unless they wait 3 years or 10 years. So it's very difficult for people to make that decision of saying, yes, I could actually be getting my green card, but that means I have to go back to Guatemala and stay there 10 years and then be able to enter. So, citizens are the only ones who cannot be deported. Okay, so that's the best status to have. Anyone who has been in the United States who has not become a U.S. citizen is still subject to being deported from the United States for any reason. So citizens have full rights to participation. They have the right to vote. By the way, if you are here, if you are not a U.S. citizen and you vote in an election, that's a deportable offense. So that's one of the questions that they will be asking in the forms. Citizens definitely have more advantages to sponsor people. The lines aren't the line, the weight isn't that long. So as we said before, anybody who's born here is a U.S. citizen. We have other countries and in other territories like Puerto Rico, American Samoa, that make people be in the United States legally. They are called nationals. People are able to obtain U.S. citizenship through their parents, and we'll cover that in a little bit. So if you have a client who, let's say is a child, and you don't know what the status of that child is, because you really have no proof that the kid was born here, then there are ways to try to find out if that kid could actually be a U.S. citizen just by asking if the parents were U.S. citizens and if the child was under the custody of that parent. People become local, U.S. citizens by naturalization, but they have to have had a green card, local permanent status for at least 5 years, 3 years if they are married to a U.S. citizen, and they must meet all the other requirements so they are not found to be inadmissible. They must show that they are a person of good moral character, meaning they have been paying their child support, they have been paying their taxes. If they are ordered to pay spousal support, they need to be up to date with that. They need to demonstrate that they are able to speak the language, and they need to know history and government, and then they have to take an oath. And you need to be at least 18 years of age to be able to go through the process. And then, as I said before, trying to establish if a child is a U.S. citizen, here are some of the most common questions that we usually look at to try to determine if the child has status. So now we're going to move to David. Why is it that parents get deported?
Feel free to interrupt me. That's okay. All of you. One of the things is, as we look at this system, we want to think about some things. Some of the things that we hear a lot of in public debate, some of the terms that get thrown around, don't hold water when we look at our system. Why don't people get in line? There isn't a line. You don't have a relative who has official status here in the United States, you don't access the family immigration system. There's no way to jumpstart that process, right? When you're married to a U.S. citizen and you haven't done your paperwork yet, you must be not trying, you must not care, you must be a scofflaw. Well, no, because perhaps this person entered without inspection when they were 18 and came to get a job and thought, if I get deported, so what? But 20 years later, they're settled, they have a job, they're the breadwinner of the family, but they're stuck. We have a lot of people in our system who are stuck, and they can't move forward in our immigration system lawfully, and leaving the country doesn't feel like a viable option because they've established a life here. They've been here a long time, and they're integrated, and their kids are integrated, and they're part of our system here. So we have that sense that the system isn't necessarily as easy to navigate as we might presume it is. We also detain an awful lot of people in the immigration system. We detain them, we deport parents. Does that mean we're getting the bad? We hear rhetoric that we're targeting enforcement, that we're going after the worst of the worst. So does that mean that if you find yourself in the immigration system, we can jump to a lot of presumptions and say, well, that's a bad person. They're being detained because they're dangerous, because they're evil, because they've done something really egregious. Not necessarily. So why is it that parents get detained? Well, one thing to keep in mind is just, you can be deported for having no lawful status. That's a ground of deportation. You're here without papers, you're here without permission to remain, you can be deported, simply and certainly for that. Involvement with the criminal justice system tends to be the way people come into the interaction with law enforcement, tends to be with the child welfare system or through law enforcement, but that may may not be for something particularly serious. It doesn't have to be for something that rises to the level of, drug dealing or axe murders or, or murderers. It can be, a DUI that results in someone being booked, and in the process of booking, it's discovered that that person lacks lawful immigration status, and at that point, they are subject to ICE enforcement, and they find themselves in removal proceedings. So it can take small triggers to get people in. In some states, 2 speeding tickets. I got one last night. I'm going to pay that because I can. But, for someone who might have not purchased insurance because they're not eligible for it, and they find themselves then not showing up in court to clear that ticket, a warrant's going to issue. So the second time they get a speeding ticket, there's a warrant. They get booked. 2 speeding tickets can get you deported. If you're lacking lawful immigration status, it brings you to the attention of the system, which then moves forward. And if you don't have a relief to that removal, you may find yourself, spending a long time in a process here. Now, this applies in Veronica. If you're not a citizen, this can apply to lawful permanent residents, people who are perfectly lawfully present in the United States. Things that are rather petty crimes get some elevated importance in immigration law. Anything that involves theft for immigration law is something called a crime involving moral turpitude. I used to represent kids in New York City, and jumping the turnstile to get on the subway, a rite of passage for kids in New York City, is charged as theft of services. For immigration purposes, that's a crime involving moral turpitude. Sounds awful. Makes you deportable, makes you inadmissible. Pretty petty thing in the scheme of what we take seriously and the types of things that we see our parents working on and going through. We have, yes?
Is there an age? Is there an age limit for that? Like under 18 cannot be deported or something like that?
We deport kids every day. 80,000 unaccompanied minors show up in this country. About 4,000 get relief. What happens to the other 76,000? They're removed from the United States. We deport kids every day. Now, a juvenile delinquency, and this is beyond where we're going, juvenile delinquency adjudication is not a conviction for immigration purposes. So that, again, may be a good way to look at it. And often, actually, involvement with the juvenile delinquency system might be a way to bring an undocumented youth to the attention of the system and work on something like special immigrant juvenile status. There might be a way to actually affirmatively give them status. So there's some ironies that abound in how that works. But, again, being brought to the attention of the system and whether or not ICE is involved, at that point, can often trigger a process that just on the basis of being here unlawfully can lead to people facing deportation and trying to seek removal from that. So we don't necessarily say that people who are detained by immigration, we detain a lot of people.
Excuse me.
Yeah.
Can I take you back to the
Yeah, absolutely.
the last one? Well, this one. Okay, the second point you have there. Well, can you tie maybe children to that, where if a child has some severe disability, is that something that can be considered, A, for the lawful permanent resident and also for an undocumented alien as well?
We have a provision in law. We have 2 separate provisions, 2 separate forms of something called cancellation of removal. This used to be suspension of deportation. When we deported people, now that we remove them, we cancel removal. So this is someone who is removable from the United States. One of the things that it permits is for someone who can prove that they've been here 10 years. This is for a person who has sex. They've been in the United States for 10 years. And they can prove that their child, their U.S. citizen child, or lawful permanent resident child, rare to see a lawful permanent resident child than you have an undocumented parent. More common to see a U.S. citizen child born here, undocumented parent. Can show that removal of the parent would result in exceptional and extremely unusual hardship. That's our standard. That's our statutory language. We used to say extreme hardship, and now we say exceptional and extremely unusual hardship. It's gone up. And the key language there that makes this a really difficult standard to meet is extremely unusual. Because all of the normal hardships that pertain to deportation or removal are discounted. Gee, it's going to be really rough on this kid to be separated from their parents, to lose the breadwinner in their family. Yeah, but that's what happens to every family that's separated by deportation. Discount that. What's exceptional about this case, what's extremely unusual about this case, so the cases that have a fighting chance in a cancellation of removal claim are often special needs cases, cases where you have a child who you say, this child would, has a special physical condition, mental condition, has special needs that would be not met if that child left the country, or is supported in a particular way by the parent being here and would be allowed to stay. So these are hard cases to win. I think they're often an example, a perfect example of how we look at the needs of children and the interests of children completely differently in a family law context and an immigration context, because we would look at this and say, gee, it's best for this kid to stay here, get the services they need, to stay in a stable environment, to stay in a place that they've known and grown up in under a family law context. Immigration might look at that and shrug and say, gee, but that's just the type of hardship that happens all the time. And we discount that and we throw that away, and we've got a much, much higher standard. It's not the best interest of the child at all. Is there something exceptional and extremely unusual about this case that plucks them out from the mainstream and provides relief? So I'm going to come back around to this, but keep asking questions as we go forward here. Detaining parents. Just to think about, mandatory detention is in place in some immigration systems where under immigration law, something for some of these theft crimes or other non-violent crimes, non-drug related crimes might trigger mandatory detention while this is happening. Now, one of the messages, I think, for this audience is don't read too much into the fact that a parent is detained. Don't read too much into the fact that a parent is facing deportation. We'll see that that has very little to say about how they're parenting. It has very little to say about how serious the things that they've been charged with. It may be simply that they are being moved through a process that's very rigid and very formal, and we attach a lot of sort of assumptions to this fact that they're detained. Oh, we can't even let them out, right? There aren't any bail provisions in immigration law. We don't let people out for that. In that immigration proceeding, that parent's not necessarily going to be represented. Only about 20% of people are actually represented in the immigration system as they move forward. Slightly over half the kids that move through our immigration system are represented. So we've got a system that's functioning without adequate sort of representation and legal input. So parents are struggling and they're trying to figure out what's going on. They don't have a lot of resources at their beck and call. They can hire an attorney if they can afford it, but no one's going to appoint one for them. Immigration judges, very, very often, similarly, don't understand what's going on in family. And they hear, gee, the kids have been removed. Now, the kids may have been taken into custody simply because the parent was detained. There may be no allegations at all related to mistreatment or maltreatment or abandonment or neglect on the part of the parent. But often we get, immigration judges looking at that saying, well, this person over here in the immigration court must be a bad person because we've got this child abuse or child neglect proceeding going on. And they make assumptions about why that got started. So the need for cross-information is fairly severe as that goes forward. Just to think about stereotypes here, who's detained. The numbers are on the left, is hard to read from back there, but basically 72% of people who are detained for an offense are for non-violent offenses. So the fact that you're detained in the immigration system doesn't tell you a lot about why you got in there. 34% of that are an immigration offense, prior immigration violation. You were here before and found yourself removed and you came back. That alone might put you, that's a third of our people who are detained simply because they have a prior immigration detention and we don't trust that they're going to show up in immigration court. So it's more of an appearance thing. Now, so where does this system lead us? And I want to sort of get us back into family court. We've been talking immigration for a long time, and now we got to get back around and say, what do we do this in family court? We have an awful lot of mixed status families. We have families that are stuck in the system. Some people have status, some people do not, and they're unable to move forward and get through the system. So these numbers, I'm going to run through these fairly quickly, and I'll give you these. 9 million people live in a family where there's at least one unauthorized immigrant there. That's a lot of people. We see that now going to areas of the country. Nebraska is among the states that we think of as an immigrant growth state. People call it a new gateway state, a new immigration state. Used to be that, all immigrants essentially, except for a few, went to New York, New Jersey, Florida, Illinois, Chicago, or California, or Texas. That was it. That was our state. That's where immigrants went. That's not true anymore. They go to Nebraska. They go to Iowa. They go to North Carolina. Right? They're following work. They're following jobs. Once family connections get set up, they're following family. So we have lots of people. They're spread around in lots of different places. 4 million parents of U.S. citizen children here. 16 million children in this country. Right? Have one immigrant parent. Now that may be a lawful immigrant parent, someone who's later become, a citizen or worked on that. Our daughter fits in that category, right? But that includes a lot of people in this country who really have connections to immigration in some way or another. We see in 41% of mixed status families, we have parents with different status. This is a good indication. Having that U.S. citizen spouse doesn't necessarily get you status in your own case and work you through the system. And it also changes power dynamics as we go forward because we've got status issues and differences across family divides and working through that. Majority of children have at least one parent children in immigrant families have at least one parent who's authorized. But we have 5.5 million children with one unauthorized immigrant parent here. We have children who themselves are unauthorized. 13% of the people who come into the United States unlawfully are kids. These are often parents who've been here and settled and found established themselves. They've come ahead and now they're trying to get their kids in. This used to be a simple thing to do. Now it's a quite dangerous and expensive thing to do because we've militarized our border and made it something that is not easy to do, and so often very bad people are involved in the process of trying to get kids to rejoin families here in the United States. 1.5 million kids are here who themselves, as they get in the system, do this. You'll often see as you work with immigrant families, as you check across the kids, younger kids were born here, they're U.S. citizens, older kids came, and they share the undocumented status of their parents, so we get a real mix of what's happening here. But we see some surprising, perhaps, patterns emerge. Children in immigrant families are more likely to live with two parents. They're much more likely to live with other relatives as well, or in proximity to other relatives with extended family networks and supports. These slides aren't in very good order here, but let me catch these. I'll stick with the slide order here. So, enforcement is up. Despite what you hear politically, we're not, enforcing our immigration laws, that there are people running around. On some level, true. 11 million people are living here unlawfully. On the other hand, in the last fiscal year, we deported more people than we deported in the 4 years of the last administration. So they've ramped up significantly. 400,000 people going through our deportation system. But, what does that mean? We're talking about big numbers here. We've got resources to deport 400,000 people a year. That's 3.6% of our undocumented population. One of the stereotypes we see about people who are walking around without authorization is that their lives are fragile, that they're very uncertain. They may face deportation any minute. Well, on one hand, that's true. They're stuck in a system that doesn't provide them an avenue to legalize their status, that doesn't provide a means to go forward, and they are probably, in many cases, without a defense to removal. Yet statistically, 3.6% focus mostly, starting with people who have criminal involvement or law enforcement involvement of some kind, are going to fall into the system. Most people walking around have absolutely no, fear other than the draw of the lottery of luck as to whether or not they would actually find themselves involved in our immigration system. I did a calculation a few years back, and I think it still holds, that said, if you don't have criminal involvement, your odds, it would take, and we have no new arrivals. For the folks who are in the criminal system and no new arrivals, it would take 89 years to deport our entire, population of undocumented immigrants. It's not going to happen. The integration that we see with families and the mixed status families and the huge numbers that we're talking about, it's just simply not a reality that we're going to see large numbers of mass deportations impacting that, which means we're stuck with a situation here where we've got people who are unlawfully present, and that has implications for their lives and what happens in family court. And how do we sort through that? It does happen that parents get deported. ICE never kept statistics on this until they were forced to under the Trafficking Victims Protection Act in 2008. In the first 6-month period we have figures for, shows that 46,000 parents, nearly 50,000 parents of U.S. citizens were caught up among that slice of 400,000, or 200,000 in that period, right? So, nearly a quarter of the people going through the immigration system have U.S. citizen children, and they have impacts here. Yeah.
Are there provisions to help these folks so that when they go, their kids can go with them, so you have an intact family?
You're right where we're going to go to. So let me make sure I answer that question, but let's get there. So where we get that. So we also have people, just as people come to the U.S., they cyclically move back. And we're actually at a time where we have net zero migration from Mexico, partly because of the economy and what's happening. But the Mexican census says there's about 500,000 U.S. citizen kids living in Mexico. Most of those are not deportation related. They're just parents who moved with their family back to Mexico. At some point they made some money and settled, or they just chose to go back and live with family there. So now we get into that. So where does this take us here? This is an actual case. This is a case Veronica and I picked up in Nevada. No, actually, this is the slide that was out of place, so I was looking for earlier. But let me say this slide. Children of immigrants are still statistically well underrepresented. We saw these huge numbers, 25, 23% of kids. Well underrepresented. We included in our materials a couple articles by Alan Detloff, who I recommend to you, in terms of sort of challenging our stereotypes of immigrants in the system, and why they're there and what happens. He's got the best information of anyone out there, so I would look at that. So this is what we don't want. This is the hearing transcript from a case that Veronica and I appealed, right? But just worth noting what the judge said. Well, if the child's born in Mexico, all right, the mom's here illegally, all right, there'd be doubt in the court's mind. Then the child is here illegally, and I have to grant the U.S. citizen plaintiff custody. This was a case where we saw a typical pattern. Mom filed for child support. Dad counterfiled for custody of the kids. Dad hadn't seen the kids in 7 years. Judge gave the kids to dad, simply on the basis of immigration status. And we just know that's wrong. We know that the fact that someone has immigration status just doesn't say a whole lot about their parenting ability. The fact that they haven't found their way through this maze, or that they're subject to removal perhaps at some point, doesn't say particularly anything. And this is where I think we need to start as a point of analysis, to say someone's immigration status per se. Now we'll talk, there are implications that go with immigration status in some cases. Someone's getting on a plane tomorrow, a family court's not going to ignore that fact as it goes forward, but status-related considerations around immigration need to be irrelevant. This is the same case on appeal, and this is what the Nevada Supreme Court said on appeal, and I think it's a good articulation. Without regard to their immigration status, parents stand on equal footing when asserting their rights to custody of their children. Ultimately, every appellate court, and we've had trial courts come out the other way, but every appellate court that has reached a version of this type of question has agreed with this sentiment. Parental rights transcend immigration status. The fact that you have or don't have a green card doesn't mean you do or don't have parental rights. This better than I do or even have been involved, but, you know, unless Maria, the mother in this case, is found to be unfit, the fact that the state considers certain adoptive parents better, right? And they were better in large part in this case because Maria was facing, you know, had been removed from the United States and was in Guatemala versus a family here, right? The presumption of reuniting the children is in their best interest, no matter what country they live in. Now we're getting to your point about saying, what happened?
Was that a TPR case?
That was a TPR case.
Because in Nebraska, you cannot raise adoptive parents and the status of adoptive parents, and termination of parental right hearings is not relevant.
It's not relevant. Now, one of the things we'll talk about is how does the status get guised as other things? Gee, it doesn't get guised as, oh, gee, she's lacking status. One of the things to keep in mind, once Maria is deported, she's no longer an undocumented immigrant in any way, shape, or form. She's a woman who lives in Guatemala. She lives in a different country. It's a country where her kids are probably citizens of Guatemala at the same time they're citizens of the United States. So we've got a little bit different going on, and we're going to get into that. She got the kids.
The kids are back, and they should have. They went to Guatemala and placed with mom.
That's right, that's right. And that's what we're seeing. You know, every time this has gotten up to an appellate court level, courts have agreed on that. And so it tells us something about where our advocacy needs to be in the trial courts to make sure we're not getting there. Again, from Angelica, right? Just that recognition that, children can be raised. It shouldn't surprise us, but it always seems to. But, billions of children are raised in other countries. They do quite well in other countries. So it is possible to raise children in other countries, and we need to look at that. That's not easy to do. See some of the challenge there. Again, we see on the record, no efforts were made to reunify. This is a challenge for our systems, for our lawyers, to work across borders, to figure out about how we do home studies and how we work across language barriers. But we need to make, efforts to make sure that, what country the children will live in is a controlling factor in determining reunification. Now, this is Michigan's, version of this, a case where our Child Protective Service immediately called ICE when they found out a parent was undocumented. The mother was put through the system and deported. And the court said, that involuntary deportation didn't constitute desertion of the children. She didn't want to do it. She was working hard and fighting through the whole entire process to hang on to her kids. And we need to look at that and see how do we transcend this barrier where immigration law comes in and works on this. One of the things we end up with in many instances is what we call de facto deportation. Immigration judges cannot deport a U.S. citizen child. Can't do it. They can deport someone who lacks lawful permission to remain in the United States. But family court judges send U.S. citizen children out of the United States every day. And they've been doing it for the last century and a half. This is well established because family law transcends this. This is one case where the kid Harold said, gee, my constitutional rights, I'm a U.S. citizen, are being infringed upon here because you're telling me I have to go live with my mother overseas. And one of two things is going to happen. Either I lose my constitutional right to live with my mother and be raised by my parents, or I lose my constitutional right to live in the United States. And the court's resolution in this case happens to be in the Seventh Circuit, but every single circuit has a case or multiple cases that come to essentially the same reasoning and say it's about the parent's choice. Because the fact that you're being deported doesn't mean you lose your parental rights. It doesn't mean that you are in a situation where we say cannot make that decision about where your parents are going to go, about where your children are going to go. So as a parent is being removed, we presume, and immigration law actually does this very expressly, it presumes that the parent is making a decision about will that child stay behind and what arrangements are being made for that, or is the parent going to take the child with them? Now, if you take away the veneer of a forced removal from this country, this is fairly unremarkable. If I decide I want to move to France tomorrow, and Veronica agrees, and France parents would take us, we're going to take our daughter along, and no one's going to blink twice and say, gee, you're taking your U.S. citizen child out of the country. Of course we are. We're making that decision in the role of parents. The case law is really strong on this, across circuits in the federal system, across circuits in our state courts as they look at this and say, these fundamental parental decisions are not easy choices because we're imposing on the parent a condition that they live outside the country in some cases, but they're still intimately involved. Question?
That's true of an intact family, but if you were divorced and you decided to move and your child was of an age where they could express a preference, then you've got a different story.
Then you do, right? But not necessarily a story that says, any more than in any case where you've got parents who are relocating to different places and you're trying to make a decision about where's this child going to live.
What's the best interest, right?
Those are hard cases
Right.
when we're talking about moving from Nebraska to Tennessee, right? It's the same thing. You've got competing parents, they're standing on equal footing,
Right.
and you're going to look at it and you're going to make a best interest determination in those cases, and you know, depending on age and how much discretion the kid has, you're going to factor appropriately the kid's, you know, wishes into that. The kid may want to stay with the parent, they may not. The key is that you're going to do exactly the same thing, whether you're moving to Tennessee, as if you're moving to Guatemala.
But
It just gets a little harder.
But you are taking into account where they're going.
You're taking into account. Now we need to be careful about, you know, sort of what stereotypes then play into our head as to, you know, is life in Guatemala necessarily that different or that better, right? Or better or worse. There are strengths and weaknesses in terms of extended family that may or may not be there, or what type of life they're going into, where are they going. Some people could be going back to, you know, if you're talking about going back to live on the streets of Guatemala, not a great situation. But if you're talking about going back to live with extended family and you've got support and you've got a network, it might be entirely the appropriate place to go. But, you know, the decisions that we have here, at the same time, they're sort of hard decisions because they're saying, gee, kids, the fact that you're a U.S. citizen and your parents leaving the country doesn't rise to a constitutional amendment. The flip side of that for a parent's attorney, and thinking about it, is it's reaffirming that parents are making this decision, because the reason that we are able to say this isn't a constitutional violation is because we're deferring to the parent's choice and the parent's role in the system, or if we've got court involvement, you know, the court system and those involvements as we go through this.
Do you know from the case law whether or not there are different outcomes in cases where the parent is adjudicated for some reason not related to immigration? I mean, if they come to the attention of immigration authorities that are having abuse or neglect of their children, does that change if they are subsequently deported before reunification efforts could be implemented?
I don't think there's a big enough pool of cases to say that there's a pattern or looking at that. I mean, there are cases where there are parents who we wouldn't reunify the kids with them here. We're not going to reunify them with the parents over you know, a season abroad. There's some cases that, you know, we got to be careful we jump to that conclusion.
When you said, though, in all the appellate courts that have reviewed this issue have essentially come to the same conclusion, and those in your experience, are those generally cases where the parent's deportation is the reason for initiating?
In most cases, although, you know, your case here in the state, you know, Angelica was a case where there was a report of abuse, right? Which ultimately the court says, you know, did not rise to the level that the kid should have been, you know, that you would, you know, terminate parental rights in that case. But that was a case that was initiated, you know, the law enforcement involvement, everything came through a report. And here we've got, you know, the Nebraska Supreme Court saying, you know, definitively, no, this woman should not have had her, you know, we shouldn't be terminating parental rights. There's an earlier case in Nebraska, and I write about it in articles in your readings, that's a matter of Mercedes. And it's similar and reaches a similar conclusion where there were sort of, you know, some low-level allegations of physical abuse, in this case slapping a child, that the court said, you know, probably shouldn't have involved even removal on any level, and it escalated to the point that the woman's deported, and we end up in a situation where we're trying to reverse parental rights.
And maybe I'm jumping the gun again, we're going to talk about this, but can you talk about the role that having the embassy go with her, because I know, again, we have a nightmare just trying to do ICPCs or the between states, that, you know, to have a different state say, you know, the home's fine, all these other things are fine. I can imagine that the farther away it is with the language, it would be more difficult.
It's tough to do. So we have a couple things going on. So you want to talk about this?
Wait, no, but keep going. Yes, and then we're going to listen to you.
That's right.
Oh, it's going to happen.
Yeah, I
Sorry.
skipped ahead to this,
Okay.
so we'll talk about that. So.
Well, you are required to notify the consulate that you have a child or a parent who is of their nationality, you know, let's say Mexico. But it doesn't mean that the consulate is going to get involved, getting them an attorney or getting actively involved. It's just that you need to notify them. And so far, with our experience, we haven't seen them being that helpful.
But
For
I'm
certain
not even
things.
talking necessarily so much about an attorney in the States, but just as even a resource for in the whole country, in the whole
Yes.
region of the country, how you can kind of jumpstart getting services in place, so that you don't hit that wall that says, wow, you know, these kids need
It is
therapy and they can't go because there's no therapy. I mean,
Yeah.
how do you facilitate from here
Right.
the means so that you can help a parent for the kid to go? Because if you juvenile court and if the services aren't in place, that's a barrier for having those kids fall off
That's
regardless.
right. It depends a little bit on your country, right? And what country you're talking about in consulate. I think, have folks here dealt with consulates? You don't have too many consulates in Nebraska, I'm guessing, right?
Well, no,
You have
I
traveled?
mean, I talked with the folks, they're not necessarily in Nebraska, but they got, you know, you talk with them in other
places. I think
places that.
I see Houston in the case law from Nebraska, right? There are a
Yeah.
lot of, Mexico and that has Houston consulates and other places. We have one in Detroit, which is, closer to us and gives us a more face-to-face relationship with them.
There's a Mexican
You
consulate.
have one in Omaha, you have a Mexican consulate in Omaha. So I think it depends a lot on the consular officer. One of the things to keep in mind is the Vienna Convention triggers notification. It doesn't necessarily say, come to the aid of any particular person or do anything. It makes sure that they know. Some countries will be intimately involved. Some countries may, on cases, pick sides and have a particular position as to where they want to go. They may not want to jump in and help a parent. They may want to jump in and help a kid who they view as a citizen of their country. And I've done this with, Mexican consulates who have been, helpful for getting documents, helpful for trying to cut through some red tape on types of identification and tracing. Not particularly helpful in terms of setting up home studies or doing other work. Germany, on the other hand, came, charging in and, wanted to reclaim what they saw as their kid and say, this is a German kid, this kid's got to come home to Germany and we're going to make this possible. But we have to keep that in mind, that the fact that a kid is a citizen of a country doesn't mean that country has any particular claim on the kid or the parent. It means the parent or the kid has a claim to their government for resources or services. And, it's going to work differently in different cases. I know that the Guatemalan embassy was incredibly helpful and resourceful in a high-profile case that people may have heard of that just has been litigated up to the Missouri Supreme Court and then was remanded back and is now on its way back through the appellate system in Missouri. And they've been incredibly helpful, exactly in terms of even using diplomatic resources. This was a woman who'd been deported to getting the State Department to permit her to return to the United States. So there are times, but I don't know that there's anything I can say other than you got to fight with your fight or work with or sort of, battle through and make claims against your embassies to and consulates to sort of tweak out any resource you can get. The Vienna Convention says they should be informed, they should be at the table, they should have an opportunity to be at the table for that type of discussion, and up to you to try and work your way through that. A couple things to think about in Nebraska on that is that you have a state statute for this that says that we need to determine this. I'm going to back up a little bit because we just have a couple minutes left, and a lot of stuff that we knew we wouldn't get to, but I want to make a couple key points here. One of the other challenges, I think, is looking hard at networks. There is no reason when you're looking for foster homes, when you're looking for temporary care, when you're looking for a place to put a kid, to preference a stranger who doesn't have any connection but happens to have been born in the U.S. but may not even speak the language of the child, over networks of extended family, over networks of community that are connected to the child and that are part of it. Judges are very hesitant in some jurisdictions to place kids with undocumented caregivers. Illinois goes the opposite direction. They expressly say, we don't care about the immigration status. I will point out that the Office of Refugee Resettlement, which deals with the 80,000 unaccompanied kids, doesn't care. This is our federal government, doesn't care about the status of people they place kids out to. So one of the challenges is to figure out why and how we do that. Yes?
Our social workers will not even consider a non-status individual because they say they can't do background checks. It just stops right there.
Yeah. So, so challenge that, I think, and push it. Can you do a background check? We run fingerprints through the FBI all the time on our folks that apply for relief because...
We have them do fingerprints, send them to the FBI.
The people won't do it. The people that we want to
But why? Okay, and I understand that you are mandatorily required to ask for immigration status. So
No. Don't have to ask for immigration status. You have to do the background checks and checks the registry, and they will not give permission for that to be done.
Some will not.
Do we have any judges in the room?
Some will not, some do.
Right? So I think that's one way to think about it is bring that to the court's attention. Raise those issues.
Here's the problem. If I'm in my GAO role or not my defense role,
Yeah.
I'm going to jump up and down all over the place because our standard is risk and harm, which is placing children with people you know nothing about their background. It's nothing to do with immigration status.
But I'm saying you can do a background check on someone. You can check registries, you can check names, you can run fingerprints. We do it all the time, whether or not they're documented.
But they won't give their permission. They won't give their permission. In a lot of cases, the parents are so concerned that they're going to end up with ice down on it, they won't even identify it.
Right.
And so if you're dead in the water, and plus in Nebraska now, you cannot place a child with a child-specific placement by statute unless they have foster care training. That's a licensed foster care. And it's really, we won't go into a lot of the provision of the non-relative placements without that. But so that's a huge barrier in Nebraska.
The licensing is a barrier to get through. But again, challenge that in the long term. And this is for folks who work with immigrant populations. Challenge that about getting people trained and certified from different communities with different language backgrounds, right? The status issue becomes a proxy for, essentially that we can't do a background check or we don't know about licensing becomes a proxy for immigration status discrimination. So as we think through ways in which we can work on this, we do need to push these issues, right? There's often, we see a lot of things that immigrants are denied for because they go to apply for something and there's a space on the form for a social security number. And whoever's helping them fill out the form says, oh, you don't have one, you must not be eligible. Well, that's not the stopping point for the analysis, right? That happens to be what the form was looking for and what's happening. We need to look behind all of these things. Now,
I may have been doing this wrong. I'm one of the judges. It wouldn't be the first time. But I think a lot of those limitations have to do if they're allured, if they're in the custody of the Department of Health and Human Services. I readily take them out of the department's custody when the department won't serve. And as I say, if there's a reasonably sober aunt in the room, she gets the kid. Because I don't have to do a background check. The statute says a judge can place with any person. We probably give priority to relatives. But if it's somebody the kid knows and trusts, that's better than splitting up the family. If you can keep them in the extended family, I prefer to do that. Then I have to fight with the department to get them to give any services. And they usually say no, and then I order them to do it, and so far they've never been.
we're out of time, and that is the perfect note to end on. I think that's exactly the approach. To strip aside the immigration considerations. Let me just offer, we're obviously, for an hour and 15 minutes, we have way more than we can talk about. Our contact is, we're easy to find. You've got our names and our contact information is easy to find on the web, or I have cards here if people want to be in touch with us. If there's any way we can be a resource to, whatever role you're playing in terms of thinking about, we put a lot on the flash drive that you got that's written, but, we can talk a little more with you in person or consult on cases. We're happy to do that. We'd like to do this, to see what's happening in different jurisdictions and how it can work, and if we can be a resource for you in any way, please be in touch. So, thank you.